Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item number 24 for respondent number 5. 24. Respondent number 5, Muda.
Your objection, Mr. Paria?
If it is for 1 week, Lordship, I have no objection.
No.
Because it's Muda, has no role.
This one
It's
we have to generate some order because as per the state government, there was never Muda, right? They never allotted it to the to the bank or to the
Mr. SD is out of station, Your Lordship.
So on that ground, it can be allowed for 1 week, Lordship.
Okay.
For 1 week.
As is reported, the Archival Council for respondent number
5.
Muda.
that is not in station. This is a matter after 1 week.
Alright.
Yes.
Please, Your Lordship, I beg to mention item number 31, Lordship. 31. I'm praying for 2 weeks, Lordship.
Who's the other
No
side?
objection.
No objection.
No objection.
Yes, 2 weeks.
Much obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 32.
Lordship, I appear for the private respondent, Lordship.
Yeah, objection.
No, Lordship.
Honorable state not represented as usual.
32.
Yeah.
32.
Yes.
Hello.
Obliged.
May I please, Your Lordship, I beg to mention item number 22. Kindly list this matter after 1 week.
22. Rajiv Jeffrey Mofa.
Yes.
No objection. What's the reason?
Yes.
Reason for adjournment?
We need to procure some documents and information.
Procure?
Yes.
Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 23 and 33, Your Lordship, fixed for hearing.
23, who's for a petitioner?
2.
I put the petitioner, Lordship, in 23. No objections, Lordship.
And 33 as well, Your Lordship. 33.
23 for?
33, respondent 1 to 4, Your
For
Lordship.
23, how long?
2 weeks,
1
Your
week.
Lordship. 2 weeks.
Any urgency?
No, Lordship, there's no urgency.
2 weeks. And 33? 33, what matters is?
33, this is creation of new village, Your Lordship.
Are you appearing? Who's for the petitioner?
I'm not for the petitioner in 33.
I'm for the petitioner, Your
Inform
Lordship.
them. Yeah, objection?
No, Your Lordship.
Yes.
Highly obliged, Your Lordship.
Before adjourning, just inform the court will see the grant or not. Yes.
Yes, Your Lordship. Highly obliged, Your Lordship.
Obliged.
Supplementary list item number 1.
Your Lordship, this is a pension matter, Your Lordship.
He died.
Yes, Your Lordship, in the year 2020.
Now, who's
The daughter, Your Lordship, represented by the legal guardian.
yes, he retired when? Died when?
He retired in the year 2020. Died on the year 2025.
He was getting pension after retirement.
No, Your Lordship. Even after retirement, no pension has been given to me till date, on the grounds that my service was not regularized, Your Lordship.
When was he appointed? 89.
1989, yes.
We have heard Mr. Majao. S.A. Majao, correct?
Yes, Your Lordship.
Issue notice, Mr. K. Victor Shaji, Bennett G.A. All respondents?
Yes.
Suspend, except to the respondents. No first required less after 2 weeks for instruction or affidavit.
Item number 2.
My Lord, here we have filed an application for impleadment of CISF.
Of the?
Impleadment of CISF.
CISF.
Yes.
Miss case number 44/2026 in the receipt number 40/2026 is an application on behalf of the petitioner to implead the Central Industrial Security Force as necessary party respondent. Number 4.
4 and 5 respectively, because one is Delhi office, another is Guwahati office.
As CISF 4 and 5. I respond 4 and 5. Seen objected to by MS Mirjam, then counsel by Dr. Endosi Karji. The misapplication is allowed. Where have you given the where have you written the
In the first, my lord, in the matter of
where have you written in the body of the petition that so and so be as 4 and
my lord, an application on behalf of the petitioner to implead Central Industrial Security Force, Block 13, CGO Complex, Lodhi Road.
represented by whom?
Page number 1, my lord.
See, Mr. Sinkon, you have to be clear.
My lord,
You can't impede the entire CISF.
I have impleaded the Delhi office and Guwahati office. My lord.
See, this is Delhi office, just office.
Yes.
And he also offers the group commandant. Okay, group commandant is fine. CSF, Suwakochi, Assam. But what about the Delhi one? Under whom? Director General. Who is he? Amended as the details, as the specific details of the respondents to be impleaded, not given in the body of the petition.
Only Guwahati office may be impleaded, my lord. In that case, only Guwahati office may be impleaded, my lord.
I don't want to impede the other one.
No, my lord, not necessary.
No. Party respondent. Yes. Accordingly, Petlico cycle nahi an office of group commandant, sama group commandant general. Accordingly, I've given the court title. The so and so stands impleaded as para number 4. Registry to make necessary corrections in the court title. And the main case, you would order passed in this case number 44. Huh? Yes. He'll accept notice. Let win 25th then.
Oblige.
Item number 3.
Wait, please, Lordship.
1 second. Yes, what's the matter about?
It's pertaining with regularization, Your Lordship. Your Lordship,
Yes, Mr. Datta.
Yes, I'll
why
file
you
a
asked
rejoinder.
Yesterday,
Yes.
who asked me to sit today? Where's Mr. Sen?
he's here, Your Lordship. Your Lordship, humbly submitted that let this matter be taken up along with the item 20 from the hearing list.
No, wait. Yes, you're appearing which respondent?
3 and 4, Your Lordship.
3 and 4 is whom?
On behalf of the University, Nehu.
You are for Nehu also. And you're for?
That's number 1.
Number 1 is whom?
Union of India.
Union of India. Then where's 2? Where's Mr. Sen? You call him. Affairs have been exchanged, yeah. Affairs have been exchanged. Affairs have been filed and exchanged.
The only paid for last.
Yes?
Yes, sir. Item 3, WPC number 361, we have already filed, Your Lordship.
Yes.
Your Lordship, this matter may be taken up along with WPC number 70 of 2024, which is listed today in hearing
What
item.
item is it?
Hearing item number 20, Your Lordship.
20. Okay, then you wait.
Item number 6.
May please, Your Lordship. Lordship, service is completed.
Are you appearing for 4 and 5? See, Khairim. come little this side. I can't see also. Yes.
Respondent number 5, the bus stand of
Number 5.
Yes, sir.
Number 4 served.
Serve. Yeah.
Then we dispose of this matter. The order will be that we dispose it of since it's come before the State Council prematurely. So what we'll do, we'll ensure status quo. Let them continue. Then number 4 decide within a certain time. Where complaints and counter complaints are there, so let them decide. You need to take evidence or something else. Let them do it. You're agreeable.
In that case, your lordship, we are agreeable in that. But the order of district council.
I don't have to go. The suspension has to go because even then, the suspension also by the Basan also it's without jurisdiction, and even the appeal filed by them also it's incompetent.
Because your lordship, our grievances, we have followed all due procedure. We have filed a complaint before the chief. Thereafter, we filed to the district council.
The only thing that he was suspended by. He was suspended.
He was suspended by the authorized by the.
So he can't. Yes, he can't. The Basan can't usurp authority. He has to come here under the. He's under the CM. If suspension has to come, it's come to the CM. So what we'll do, we'll remove the District Council. We'll remand it back to the CM for this. And meanwhile, let him continue. Yes.
Oh, will be in the short period since we are aggrieved of financial irregularities and the detrimental conduct of the
But one thing, Mr. Harindo, we have to set a procedure straight first. That's the only thing. All the procedures straight, and but number 4, you're not preventing him.
No.
Suppose
Can we decide his absence?
Who was
Also another issue. We'll post it after 1 week. We'll just say you file after service.
Yes, we have filed.
After service. Yes. Yes, affidavit of service has been filed. We record the factum of service upon respondents 4 and 5. Stop MSEDCM today is entered appearance on behalf of number 5, but there's no appearance as yet on behalf of number 4. Stop, for the ends of justice, let the matter be posted over 1 week to enable appearance upon number 4. You inform them about the the observation of this court. You'll dispose it off after 1 week. Yes.
Daily list item number 1.
Please, the limited issue here, is whether for the default of one consumer, the electricity of another consumer can be disconnected or not. That's the only limited issue. Because admittedly, insofar as my bills are concerned, that is paid up to date. I'm sorry, Militz.
Where's your opponent? You are ready with the submission?
No, not sure. Yes, Pandey will be on.
After Sunday? I'll keep your lordship's waiting.
Tomorrow. There's no urgency.
There is, Militz.
There's no urgency, Mr. Paul. You understood.
Militz, that day, I was on VC, but there was some difficulty, Militz. At the end of the board, Militz, because tomorrow again I'll have some difficulty, Militz. I'm not in.
Make sure it's on board.
Not sure.
2.
What should I?
Oh, may I pray, Militz? Militz, I'm not pressing for an interim at this stage.
Issue notice.
Let notice issue, Militz. Let them file an affidavit and your lordship will have it next week then.
Yes, heard Mr. K. Police Counsel, assisted by so-and-so. Ms. S. Lalu is present on behalf of respondents number.
All the respondents, sir.
The respondents, no further notice required. Was already recorded, right? This the matter after 1 week for instructions. Affidavit.
Item number 2.
Your lordship, that just part to come after 2 weeks, your lordship.
It's for admission.
Yes, your lordship.
It's been pending for quite some time now.
We'll admit it.
We've only made a suggestion that the entire matter may be dealt with. The orders may be set aside and remand back to the presiding officer.
No, but the counsel is not here, so what are we going to do?
We've had a suggestion before.
Yes, due to unavailability of the arguing counsel, we have the appellant. That this matter will list after 1 week. Yes.
3.
Please, Melits. This is a review application, Melits. That limited issue which was there before my lords is, Melits, the order itself was signed by the CEM, Melits. I'll take your lordships to the operative portion of my lord's order. Page 234, Melits, paragraph 11.
Who was appearing for the council here?
Mr. Marpan was there.
Where's Mr. Marpan? Yes, sir. We're 234.
Melits. Para 11, Melits, if my lords can have a look. If my lords have it.
Yeah.
In the proceedings before the tribunal, therefore, it can be seen that it is not a case of denial of opportunity or that, as alleged by the writ petitioner, there has been violation of the principles of natural justice, and on this ground, the plea of the writ petitioner in this regard fails. However, coming to the order and appeal dated 21/12/2023, though the executive committee had heard the matter in detail and upheld the order of the tribunal, the said order was signed only by a single member of the executive committee, which therefore would render it incompetent in variance with Rule 31 of the AD rules, which provides as follows. Each member of the executive committee shall be entrusted with specific subjects, the allocation of the subjects being made by the chief executive member. The executive committee shall be collectively responsible for all executive orders issued in the name of the district council in accordance with these rules, whether such orders are authorized by an individual member or of the executive committee on a matter pertaining to his subject or result of discussion at a meeting of the executive committee or howsoever. The order in appeal, therefore, in the absence of an authorization in accordance with the rules of 51, the impugned order dated so being signed by only one member is liable to be set aside. Now, the order, Melits, this order was signed by the CM himself.
Okay.
So it is not a case of Melits being signed by one individual member, because the rules otherwise say, Melits, that the orders are to be signed by the CM, and if not Melits, then by two members. I'll take your lordships to the impugned order, Melits. The order concerned. Just give me the page of the order. Page 64, if my lords can have a look.
Who appeared before for the respondents?
My friend Mr. Shangrizo appeared, Melits.
64.
Well, if my lords, can I have a look at page 69? Show me the rules.
Yes.
It's signed by the chief executive member, Melits.
Okay.
So therefore, Melits, this may not, probably, Melits, it had been pointed out, but we might have missed it, Melits, at that point of time.
You were there at that time.
I'm sorry,
You
Melits.
appeared in this
Yes, Melits, I had appeared. We had pointed it out, Melits, that it's signed by the CM. Also, there were two issues. One, that it was signed by the CM, and the other, Melits, the Ilaka rules do not require two members. That requires only one member. But
Yes,
that is not...
Marpan, what do you have to say?
I agree to that submission.
Yes. Where's the rule?
Melits, the AD rules. No?
Not Kanye, this is a...
If my lords kindly have a look at Rule 28, my lords, this book is probably, my lords may refer to this.
That is a reliable one. Obligation of the government.
No, the AD rules. Rule 28, my lords.
Yes. Yes. Yes, so take down. So we have to reconsider the matter now. Mr. Changri, so you're the petitioner, correct? No, who was the petitioner in the...
Petitioner is my friend, Mr. Shangri.
Yes, in the main writ petition. So we'd have to...
The review would have to be allowed and matter restored back to file.
Restored back for consideration.
Yes.
Has there been any developments?
Only on that limited issue.
Yes, take down.
we submit this regarding the review.
Yes.
According to me, my lord, the Rule 28 of 1951 operates in different field, and Rule 31 quoted by my lord is operating in different field.
Show me Rule 31.
Yes.
I just submit.
Yes. Come to
Let's
side.
see. 1951 rules. 28 quoted by my friend just now. It says conduct of executive functions. But so according to me, my lord, this is different from the my lord Rule 29 and 3031.
Yes.
Now Rule 28 may I read, my lord?
Yes.
My lord. Conduct of executive functions. The executive functions of the district council shall be vested in the executive committee. All orders or instruments made or executed by the executive committee shall be expressed to be made or by an order of the district council. Every such order or instrument shall be signed by the CEM or any other members of the executive committee authorized in writing by the CEM in this behalf, and such signature shall be deemed to be the proper authentication of such an order or instrument.
Yes.
So my first submission is, my lord, if there is an instrument or other order in discharge of the executive function of the district council, then it can be signed by the CEM or authorized to that particular person by the CEM. Now this is the operate in different field. Now when we see the Rule 29 onwards, function of executive committee. Now I will come down to 31, where the order quoted, transaction of business of the executive committee. It says, well, each member of the executive committee shall be entrusted with specific subjects. The allocation of the subjects being made by the chief executive member. The executive committee shall be collectively responsible for all executive orders issued in the name of the district council in accordance with these rules, whether such orders are authorized by an individual member of the executive committee or a matter according to his subject, or as a result of discussion at the meeting of the executive committee, or howsoever otherwise. Now, therefore, my humble submission is the impugned order was signed by CEM. Now, my humble submission is CEM is not the executive committee. He's the first member among the equals only. Now, here under the Ilaga Act, it says that all the appeal passed by the tribunal will be heard by the executive committee. And executive committee, Ilaga Act 1991, madam. Just see.
Go into the Ilaga Act.
Ilaga Act, 1991.
Yes.
Where's the Ilaga Act? Mark the Ilaga Act.
Madam, can you see definition section 2, Roman number 3, executive committee is mentioned.
This is the unamended one.
Definition of executive committee is mentioned there. Kasir's Autonomous District Administrative Ilaga Act 1991.
Yes.
And when we see this section 4, Section 4, boundary dispute between ilagas.
Yeah.
If a boundary dispute arises between two or more ilagas, or between an ilaga and a village of another ilaga, or between two villages of different ilagas, the dispute shall be referred by the ilaga or ilagas concerned by a petition to the tribunal constituted by the executive committee for the purpose which shall decide accordingly. Now I'll come to an appeal against any order or decision of the appeal tribunal shall be referred by the aggrieved party or parties by a petition to the executive committee, and its decision shall be final. Now here the executive committee. Now my humble submission is that CM is not executive committee. He is the head of the executive committee, my lord, but he cannot represent the executive committee.
Where is wasn't heard by executive committee? We thought that the case is heard by executive committee but signed by one member.
But no, it was heard by the CM.
And CM out of the record, my lord, CM heard it, and the petitioners, the respondent, the review applicants, is the younger brother.
No, he was the deputy CM. That's not correct. CM at that point of time was somebody else. He was the deputy CM.
Who was deputy CM?
Deputy CM was the elder brother, Militz. But the matter was heard. That's why it was heard by the CM.
Of the power. But my
so
party
therefore, the matter was heard by the CM.
Side, my lord.
That was heard by the CM.
Therefore, I said out of the record, my lord. Now, see here, the executive CM heard the matter. And in the last occasion, Lordship directed the Esteem Council to representing the district council to produce the record, whether there is authorization given to that particular chief executive member to hear or sign the petition. My colleague did not produce it. So my humble submission, my lord, the ground taken by my esteemed colleague is with regard to the interpretation of the law. And lordship is very aware, in a review jurisdiction, my lord, wrong application of law or interpretation of law cannot be the ground for reviewing the order. Otherwise, Rule 31 is lordship has quoted in the order itself. Yes. If there is no collective responsibility, one person can handle it. But it says collective responsibility on behalf of the...
No, but it's come to Ilaka, I guess, Mr. Paul.
Well, it's under the Ilaka Act. I had pointed out, well, this is the second limb of my submission. Under the Ilaka Act, this order, there is an amendment to the Ilaka Act. Now, this amendment, comes in it's published on the 9th of October 2024.
Yes.
So, post-amendment, give me another copy of the post-amendment. Post-amendment, Section 10 was included, in the original act, which my lords would find in the book. It's up to 6. This is the amendment. Give me another copy. So, my lords, may I kindly see post-amendment, Section 10 is included, which says the executive committee...
Which is parameteria to all the other acts
Lodge.
With regard to succession.
But the order here, my lords, is prior to the date of the amendment. So, this amendment comes in
2024.
Yes, my lords, it comes in 2024, whereas the impugned order, the order, my lords, under challenge is dated. This order is dated 21/12/2023.
Yes.
21/12/2023. So that is prior to the amendment. Right on top, let's see. Date of hearing 17/10/2023. Date of order 21/12/2023. So there was per se no requirement under the Ilaka Act, for that to be signed by 2 members, because that amendment comes in only in 2024.
No, but one thing, was it heard by the executive committee or by the CM?
CM, my lords. It is heard by the CM.
So executive is collective.
It is collective, my lords, but that's why I take your lordships back to Rule 28. That's why I take your lordships back to Rule 28.
Yes.
Because the language of what my learned friend is submitting, my lords, the language of Rule 28 is very interesting.
Yes.
28.2, my lords, may kindly have a look. All orders or instruments made, it's not only instruments, my lords, what my friend was saying, all orders made or executed, my lords, I'll skip executed, made by the executive committee shall be expressed to be made by or by order of the district council. Every such order, I'll skip out instrument, shall be signed by the CM. In the first instance, my lords, it has to be CM. Then the expression used is or. Any other members of the executive
coming to other part, fine, was signing. Was it heard? Now his submission is that it was never heard by executive committee.
Well, that's not his case before your lordships in the writ petition.
That's not the case.
That's not the case. His only case was, my lords, that he has not been accorded an opportunity of being heard. That my lords have given a categorical finding saying that you have been given not only an opportunity of being heard, you've been given repeated opportunities of being heard. You've never done it.
There was never a ground taken.
Well,
that's not his case.
Ground was not taken.
That's not. That's not. So, in my lords, in my review, we cannot now take that ground.
No, I'm not taking that.
It's actually a very, crucial point.
It is.
If the act provides that executive committee is here and is heard by CM, that
is why, my lord.
That would have to be a separate challenge.
Rule 28 operates within a different field.
No, we're not going to go there.
It doesn't emphasize the collective responsibility, my lord. Rule 28, my lord, do not emphasize collective responsibility, but that is a function of the council.
All orders and instruments made executed by the executive committee, made or executed by all orders. Does not say whether it's quasi-judicial or it's plainly executive. Correct. So now this exercise of power by the CM or executive committee in such matters is quasi-judicial.
Quasi-judicial.
So that's the thing.
Therefore,
it doesn't make me
therefore it falls. Lordship is correct. Therefore, it falls the quasi-judicial power exercised by the executive committee under 31. under 31, my lord, quoted by my lord, it is required to be done by the executive committee.
But then you have not taken
That's not the case.
Ground was not taken. Therefore,
That's not the case, Melons. Now we cannot become wiser.
No. I did not. I cannot go beyond the pleadings. I cannot take
Mr.
that plea.
Marpan, has there been a development after the order of this court?
No, nothing as such. To add to what the Senior had submitted regarding Rule 28/31, Lordship in the order which was passed, Lordship had referred to the one Jana Rule 31, saying that it is invariant to that Rule 31. Now, 31 only in the case when the subject matter is in a footpart, that order which is referred to.
Footpart?
Footpart. This in the subject matter of a footpart.
Well, that's the other case which my lords had referred.
Now,
That's
this
not
one
under the Ilaka
is
Act.
before your lordship. Is with regard to the boundary dispute. So that is the thing. That's a distinction.
Because, well, it's my humble submission here would be special law would apply.
Yes.
So, well, it would essentially have to be under the Ilaka Act.
Take down the instant review application has been filed seeking review of judgment order dated 24/11/2025, passed by this court in WPC number 81 of 2024, whereby it was held that the order in appeal dated 21/12/2023, passed by the Executive Committee, was incompetent, as was signed by only a single member of the Executive Committee. Stop. Mr. K. Paul Leonard, Senior Counsel, on behalf of the review petitioner, has submitted that the review has been necessitated in view of the fact that it was not brought to the proper notice of the court that the order was in fact not signed by a single member of the Executive Committee but by the Chief Executive Member. Then stop. The Senior Counsel has then taken this court to Rule 28, one of the Assam and Meghalaya autonomous districts, now within bracket Constitutional District Councils, close bracket Rule 951, to show that the Chief Executive Member, an order passed Chief Executive Member, would be valid on any order instrument passed or executed by the Executive Committee. He therefore prays that in view of the operation of Rule 28, the order be recalled and the minute petition be taken up for consideration. Stop. Next paragraph. Mr. H.L. Chanreso, Learned Senior Counsel, appearing for the respondent writ petitioner.
You respondent writ petitioner. Number one.
On behalf of the respondent stroke writ petitioner has in reply has submitted that Rule 28 will not govern the field, and in fact Rule 31 will be very much applicable, inasmuch as there is a collective responsibility of the entire Executive Committee in hearing such matters. Mr. Marpan with submission. Mr. S. Marpan has
I'm endorsing the submission.
Mr. S. Marpan appearing for the District Council, however, as for District Council respondents 225, however, has endorsed the submissions made by the Council and submits that in the instant case, as the order has been signed by the CM and not by a single executive member, the order would be valid. So, now this court has heard the submissions of the Council of the parties and also examined Rule 28 So for the sake of convenience, the said rule is reproduced here and below. So, next, perusal of the above noted rule, especially 28.2, would show that though other members of the committee would necessarily have would have to authorize in writing, in the case of the chief member, such authorization is not necessary, and he would be competent to sign the order in his own capacity. Further, it's noted from the it is noted that the act under which the instant case has arisen, that is the Khasi Autonomous District bracket the Vilaka Act. The original one is 1991.
Yes, 1991.
1991 has since has since been amended, wherein section 10 has been added with regard to delegation of powers. Powers whereby powers, and it has been provided therein that the executive committee, while hearing matters under the act, by order notification, can empower 2 or more members to exercise on its behalf any power or powers conferred upon by the act. However, as submitted, this amendment has come into effect only on 9/10/2024, whereas the impugned order in question was passed as far back as on
21/12/2023.
As such, a considered view of this court, the said amendment, though very relevant, will not have no application in this case. Next paragraph. Accordingly, for the reasons stated, the review application is hereby allowed, and the order dated 25, order dated 24/11/25 shall stand recalled. The WBC number 81 shall be restored to file and be listed for the orders accordingly.
Well, it's restored only to the limited extent of this, limited extent of
restored, it has to come back to wherever it was.
It's because otherwise, because others it will open up the entire arguments. At my instance, his
once restored, then now we have given him a handle. Right. Then he is free to do whatever. We're not going to see anything. Yes.
Pleasure.
We'll keep this.
Obliged.
Item number 4.
Yes, where's Mr. P.T. Sama?
Says out of station, Lordship.
Yes.
Whether you'll do it or not?
May I please, Lordship? You filed the rejoinder, Lordship.
What rejoinder to?
To the state respondent, Lordship.
State respondent, you file objection?
No, Your Lordship. We have filed, Your Lordship.
Yes, I filed.
You won't file objection. Yes, you filed rejoinder?
Yes, Lordship.
Already filed?
No, Lordship. Some more time, Lordship.
Right, so Marak praise for to file rejoinder to the objections filed by reply to the objections filed by the state respondents.
Lordship, yes.
Next for MS Rahman for the respondent number 527 submits that the state respondent rely upon the affidavit filed by the state respondent just after 2 weeks.
After 2 weeks, Lordship. Apply, Lordship.
5.
So contempt, we file an affidavit saying that
complied.
Not fully complied, my lord, but is in the final stages of compliance, my lord.
Have you got affidavit?
Yes, Your Lordship. They filed additional affidavit. I've received it today.
Received when?
Today.
What is the affidavit? It's in record.
It's filed.
It's not on record.
It's in the process of filing. Madam, what we have said is, you can just hand over my. Para 2.
It's still not compliant. Still on the journey.
No, madam. Ministry has approved it already. MHA is already approved, madam. Now some final stages of approval.
Withdraw the contempt.
Lordship, it may be posted after 3 or 4 weeks, Your Lordship. Then.
Dr. N. Musica Leonard DHGI with so and so submits that the orders needed to be violated are in the process of being complied with. A communication dated 29/01/2026 also produced to substantiate this fact. Accordingly, this is matter after 4 weeks for further orders. Copy of the communication will. Oh, this is your affidavit, sir.
I'll give a copy of it.
You just file affidavit. Yes.
Yeah, 6. Oblige, Your Lordship.
Yes, my lord. My lord, my rejoinders are ready. But then, my lord, please give me time to file them on Monday. The petitioners couldn't make it on time for the signatures.
Last opportunity.
Yes, my lord. My rejoinders are ready. I'm just waiting for signatures.
You pay cost then.
My lord.
You are appearing for?
Yes, for respondent 6, 7, 8.
Who are the other respondents? 1, 2, 5?
I'm for 5.
I'm for respondent 13.
I'm for respondent 9.
What's the matter about?
My lord, this is with regards to the illegal construction of the mobile towers. Without
still pursuing that matter?
Yes, my lord. My lord, they are very poor people. They are from Umsala. They need to come all the way from this.
Yes,
I'll file on Monday.
MSOI Bank, then the council petitioner submits that though the rejoinders and that's it are ready, the deponents could not come, could not sign this, could not come to.
They could not come today.
Due to unavoidable circumstances, just after 2 weeks. Yes.
Yes, madam. I'll file under the course.
7.
Lordship, I'm praying for 2 weeks' time to file the affidavit.
What about settlement talk?
Lordship, they have never come. They have never turned up for the settlement talk. I'll seek instruction, Your Lordship.
Yes, a pension matter.
Lordship.
So why didn't you come to settlement talk? Anyway, further you file. Mr. K.B. Varasaji appearing for whom?
I'm for the state.
And S. Lalu is appearing for 2 to 5.
2 to 5.
And you're appearing for 6. You're not filing affidavit. Mr. Varasaji, MSS Lalu for response 2 to 5 and EB Prasad for 6. Therefore, not for the 2 weeks time for affidavit. Yes, there are concerns.
8.
What should I? May I please, Your Lordship? Lordship, I'm praying for 3 weeks' time to file my rejoinder, Lordship.
3 weeks too long.
2 weeks, Lordship.
None didn't appear last time. Also.
Yes, Your Lordship. I missed the matter. I apologize, Lordship.
2 weeks by the time was paid allowed for
Deeply obliged, Lordship.
9.
May you please, Your Lordship? Your Lordship, I'm filing my affidavit in the course of the day, Your Lordship.
Yes. MS Ailingwa, Leonard GA submits that after behalf. You appear for all respondents?
Yes, Your Lordship.
Correspondence will be filed in the course of the day. Just after?
1 week, Your Lordship.
For rejoinder?
Lordship.
For 1 week for rejoinder, if any.
Much obliged, Lordship.
Yes. After the file. Why?
Some clarifications are required, Your Honor.
You got instructions?
Yes,
What's the
Your
matter about?
Well, it's non-payment of
Pensionary benefit, my lord.
Your Honor, apologies, but some clarifications are required, Your Honor.
What
Your Honor, the petitioner had not joined service in the place of posting, in his new place of posting since 2008. So we've sought for some clarifications, Your Honor. Just a short date.
My lord, we have received a notice from this honorable court. It's fixed for Lok Adalat. Yes, my lord.
Well, then you try to resolve it in Lok Adalat. As reported, the matter is fixed for on the 14th.
14th, my lord.
Yes, list thereafter. Respondents also to file affidavit in the meanwhile. Yes.
11.
Wait, please, Your Lordship. Your Lordship, I'm praying for some time to file our affidavit.
How many times?
Your Lordship, this would be the 4th time.
4th time. Any urgency?
No.
No. For a 2 weeks time, it's straight allowed for affidavit.
Obliged, Your Lordship.
12.
But here the concerned officer has requested for some time, my lord, for the parawise comments. So kindly,
He's missing.
Requested for my lord, the officer has requested for some time for the.
Officer requested.
So my lord, I am also seeking some more time, my lord.
What's the matter about?
VC matter.
VC matter, my lord.
Mr. K. for 1 to 6 and around 70 for the 7 and 8. Not for 2 weeks time for affidavit.
13. 13.
For the state, Your Lordship, I'm praying for some more time, Your Lordship.
Your Lordship.
This is together with 6 and 5 just now.
Lordship, VC matter, Your Lordship, both are.
Same order. Just 2 weeks time allowed for affidavit.
14.
Please, Your Lordship, we just require another week's time to file our affidavit, Your
What's the
Lordship.
matter about?
Your Honor, removal of sub-inspector.
Sub-inspector.
Yes, Your Honor.
You have to wait for the 2 weeks time allowed for affidavit. Yes.
15.
Your Lordship, I seek 2 more weeks' time to file my counter affidavit, Your Lordship.
Yes, Miss, we have now prepared for about 1 week's time only.
2 weeks, Your Lordship.
2 weeks time.
Highly obliged.
Highly obliged, Lordship.
16.
I've taken steps, Your Lordship.
You've taken steps?
Yes, Your Lordship.
Lord, I'll be appearing for the respondent number 4, my lord. Respondent number 5 has been named. He's the secretary, but he is not the present secretary, my lord.
Return answer, Mr. Pasante. You obtain correct address, correct person. Yes, Mr. Ensign Confidence entered appearance on behalf of respondent number 4.
Yes, ma'am.
However, with regard to respondent number 5, the office note indicates that the same written unserved. Mr. Pasante to a certain correct person and address. Take 5 steps.
This person, he is no more the present secretary, my lord.
No matter, they will find him. Just after 2 weeks.
17.
Please, Your Lordship. I'm praying for some time to file our affidavit.
Who's Mr. M.H. Chowdhury? The 3 weeks time was paid allowed for affidavit. None appeals for the petition.
Highly
3 weeks
obliged.
time was paid allowed for affidavit.
18.
Lordship, we are yet to receive instructions. The Lordship may kindly allow us 3 weeks'
What's the
time.
matter about?
This matter is about a pension matter, my lord, and even the revised, the revised payment
Fixation of pay.
Yes.
2 weeks. 3 weeks time was paid allowed for affidavit.
19.
Lordship's last order, the petitioner was directed to Lord's examine whether the matter is subject matter of an alternative remedy.
Yes, Mr. Pasantia.
Your Honor, here we are seeking for fresh electricity connection, Your Honor, Your Lordship. So electricity is a fundamental right, Your Lordship.
No, not fundamental right. You want to pursue this matter?
Yes, Your Honor. Yes,
The alternate remedy you have the consumer.
That is with regards of electricity. That is with regards of electricity is supplied to us, Your Lordship. But here electricity was denied.
It doesn't cover. Mr. Pandey is not, his grievance is not covered by the alternate remedy available.
No, that is incorrect. That is, the regulations are there. My friend is carrying a copy of the regulation.
Where are the regulations? Yes.
There are two regulations. One is the CGRF regulation of 2017.
Yes, this is 2017. Regulation number?
And 3. Nature of complaint and its registration. And item number 3.1, Roman 6, complaints related to disconnection and reconnection of power supply. And also, Milord's,
where reading from?
I am reading, Milord's, regulation 3.
Oh, but
it is headed as nature of complaint.
But MSS Lalu has not given page number 3 and 4 of this compilation is missing from here. You check. Where's page 3 and 4 from that compilation? Please be careful when you do. Yes.
Nature of 3 is nature of complaint and its registration.
Yes.
I apologize.
No problem here.
Nature complaint and its registration. And 3.1 Milos, the consumer complaints are to be classified for convenience of handling into the following categories. And then your lordship's item number 6 is complaints related to disconnection and reconnection of power supply.
And 7.
And 7 is complaints due to new service connection or extension or reduction of load. So new service connection is something which is categorically covered by these regulations.
There's a possibility you didn't examine these.
You can just fix the matter for admission hearing on.
Admission hearing? You take instruction. Otherwise, on our own court will pass the order. Yes, there's a possibility of praise that he may be given 1 week's time to obtain proper instructions. Just thereafter.
Hearing? Hearing 20.
This is a case, my lord, when last occasion, my learned friend has produced a copy of appointment letter 2011. A similarly situated person, my lord, who has been conferred with temporary status, he has been appointed. So your lordship asked me to obtain the instruction. So I have obtained the instruction, my lord. What happened? There were as many as, my lord, 19 temporary status employees, my lord, who were repatriated from Nagaland. Because the university had a campus there. They were repatriated here and they were granted, my lord, temporary status. In 2006, they filed a writ petition. Their prayer was for a direction to...
Where they filed it here?
Yes, my lord. Yeah. For a direction, my lord, to regularize them against the Group D post. So this matter was ultimately, my lord, decided in the year middle of 2009. When, my lord, this abolition of the post, that process has started, it has not reached the university. Now I appeared for the university and I made a submission, my lord, because there was a recommendation from the university also to regularize them. There was a
order of the court.
I'm just placing. And my submission was...
You've got the copy of the order?
Yes, I'm giving.
Anyway,
I don't have the copy. Yes. And my submission was, my lord, the court has given a direction, regularize them, subject to the approval of UGC. Lordship will kindly see, my lord. This hour. One more is there.
Yes, will come. Where's the direction, Mr. Sen?
Lordship. Now, my lord, thereafter, my lord.
Where's the direction?
Yes, my lord. Thereafter, my lord, we wrote to the UGC. And ultimately, my lord, after, my lord, the post was abolished, my lord, that was in our consideration. Ultimately, your lordship will see kindly in that bunch, my lord, there is a letter dated 21st April 2011 from the UGC. My lord has got it.
21st?
April 2011. I'll just read it. To the register. Consider the matter relating to 19 employees on temporary status, R12 Nagaland campus on Northeastern. With reference to your letter number such and such subsequent above, I am directed to inform you that the matter was placed before the Commission in its meeting held on 28 March 11 for consideration. The decision of the Commission is reproduced. The Commission considered the issue of regularization of 19 employees of R12 Nagaland campus of Nehu and decided that the action with regard to the regularization may be taken by the university as per DOPT norms stipulated in casual labor grants of such and such 1993. So pursuant to this, my lord,
when was it abolished?
Well, that was abolished.
No, when this letter was issued, already abolished.
By that time, my lord, already abolished. That was also, my lord, in my, I have annexed the relevant documents in my Nehu's affidavit. If you kindly, your lordship, see, we have adopted it. The date of adoption and other things are there. Nehu, if you kindly, lordship, take up the affidavit of the university. Page 11. Lordship, kindly come to page 11, my lord. When the abolition was extended to the university formally by the UGC. April 2011.
Yeah. Yes. It says.
It says, my lord, model recruitment rules group C. I am directed to enclose here with a copy of model recruitment rules group C post. Such as you are requested to adopt the same with the approval of the competent authority as per the rules. If the university has already advertised any non-teaching post group C in such and such, the grade pay of such and such, which deviates from the enclosed model recruitment rules, the corrective measures may be taken immediately. Now on the next page is the model recruitment rules. Now, my lord, it
say abolition of group D post.
This is the one, my lord.
April 2011 only.
Yes, that is 30th April 2010. The sixth,
the abolition of the. What is the one?
This is the one, my lord. Number one. There will be no further recruitment in group D post.
Yes.
Now this was formally adopted by the university, my lord. If your lordship come to page 14, this was placed before the EC. And EC took a decision on this matter and notified on 26 July 2011.
No, this is a part of Annexure 3.
Yes, ma'am. This is a part of it.
Okay.
Recruitment rules.
Should have marked a separate annexure actually.
No.
Should have been marked separate annexure. But anyway.
My lord.
Yes.
Now, my lord, next page 14. University took a decision, EC took a decision and notified. That is 26 July 11. It is hereby notified on the recommendation of the Executive Council in its meeting held on such and such. The resolution has approved the model recruitment rules for Group 3 posts in the payment of such and such, such and such, such and such, with immediate effect. Pursuant to the 6 CBC approval recommendations and the aforesaid instruction of the UGC and the DPT, there will be no further recruitment in Group D posts. So, my lord, we are under obligation to implement it. We have implemented it, but since there was a court direction, my lord, that also we did not take a decision. That matter was sent before the UGC, and UGC ultimately approved. So here also, my lord, since, my lord, they stand at par, my lord, we admit it. We have sent their case. There are altogether now 12 this kind of employees, my lord. 12.
No, but it's 21 11, 21 April 2011, they also just give you the request to take appropriate action in this regard.
Lordship.
The Commission considered the issue of Regulation 19 employees of the erstwhile campus and said that action with regard to regulation may be taken as per DOPT norm, stupid and casual labor, grant of terms.
So, my lord, right now, my lord, there are 12 this kind of employees. All the writ petitioners, my lord, in different writ petition, all the 12 were before my lords, the connected matters. 9 are in this petition, and 3 more writ petition, my lord, which your lordship is taking.
Mr. Datta.
So, my lord, I think last occasion UGC has placed some instruction, my lord, their inability not to regularize. If that is so, my lord, the only way out is to, my lord, file a case against the UGC.
See, the thing is that even though this UGC letter is not so clear, but even then, if the Commission considers so as stipulate right to action with regard to this. So once you have given that casual labor grant at 93, they were allowed regularization. That's it.
So, my lord, here we expect, my lord, if that kind of instruction comes, my lord, we have
my lordship, please come to this office memorandum of 30th April 2010, the last para 5.
Yes.
The Ministry of Home Affairs, etc., are requested to bring the contents of the OM to the notice of all attached/subordinate offices. The autonomous statutory bodies may adopt the same with the approval of the competent authority as per the rules and statutes. This has not been adopted, Your Lordship. Formally not adopted.
What about notification?
Yeah, they have not circulated the notification, and moreover, there is no approval from the competent authority.
UGC is the competent authority. They have extended it.
It is being used just to stall our.
Mr. Datta, I don't think your submissions.
UGC has formally extended, my lord. I have taken your lordship. Then it was placed before EC, and EC has formally taken a decision.
And you're not qualified for Group C post.
Your lordship.
You're not qualified for Group C post.
So only thing, my lord, if now they are agree, my lord, that decision my learned friend of UGC has been placed, they can challenge that decision, my lord. That's the only thing.
Because
our hands are tied.
It's very unfortunate.
Yes.
I think that these other people are suddenly placed, and this notification has come 21st April, but even then it's adopted by the NEHU on 26th July. So before adoption by NEHU, they were given, this letter of UGC had come.
And there is continuation.
And after that, they were regularized. From which date, Mr. Sen? These other people?
The regularization, my lord, regularization.
No, in the meeting. When is the meeting held?
Meeting was held, my lord, last page, your lordship comes.
2nd September.
2nd September.
So they were acting only on the basis of the 21st April 2011 letter.
Exactly, my lord. Our same case is same here also. If it comes.
And the person to whom they have appointed, he is also underqualified, not qualified as required according to this.
We're looking at a broader picture. See,
yes.
The thing is that you're asking for a revision in Group D posts. Correct. Now, Group D posts, they're discontinued. There will be no further recruitment in Group D posts. So you cannot be regularized in Group D posts post 26 July 2011. The other case you brought is that before this 26 July 2011 came, UGC had by letter 21st April said regularize them. So even though the action was post the elimination or the what is this, the abolishing of these Group D posts, they were concerned and regularized. So what Mr. Sen says is correct. You have only a quarrel with who's referring UGC. The same consideration should be given to you also.
Actually, UGC in their letter that of 22nd April 1998.
No, we're not going 98 because what is very relevant is the latest one. Mr. Sen, I think for the matter to be closed, you'll have to place this on record, this letter that this.
No, you can keep it on record, so I've given him the copies also.
So, Mr. Datta, you want to pursue the matter? We'll pass judgment.
I'll have to take instruction, Your Lordship. In that case, I cannot take any decision.
It's clear because that's the only thing that last time it brought that question that was a bit disturbing. That letter, yes.
Yes, Your Lordship.
So it's good that you're pursuing the matter with due diligence. Yes, Mr. Sen today, Mr. Leonard Counsel, Mr. Sen for the university has produced certain documents with regard to the regularization afforded to other similarly situated employees post the abolition, post the non-continuance of recruitment and group B posts. So it is submitted that the realization was done on the authorization on a letter dated 21 April 2011 of UGC, which had allowed the university to take appropriate action as per the norms as stipulated in the casual labor grant of temporary status and regularization scheme of Government of India 1993. So, Mr. D.K. Datta has been provided with the order of this court passed in WC 252 SA 2006 and also the other materials phrase that will be allowed to obtain instructions. List after 2 weeks, yes. Will this board next?
Obliged.
Well, rather, sir, these are similar matter. Item number?
List together is
3, 4, and 5. Same issue.
21.
I have given you.
May I please, Your Lordship? It appears the private respondent number 8 is not present here with us, and there's urgency the matter, Your Lordship.
Who's number 8?
Number 8 is the serving candidate, the serving teacher.
The
teacher who is serving in the school.
Who appears for number 8?
Mr. Paske, my lord.
There's urgency in the matter because it pertains to deprivation of salary.
You're out of service or in service?
I'm still in
The
service,
petitioner
Lordship.
never joined service. Our affidavit, even the affidavit submitted by the private respondent, clearly says he never joined service in the school.
This number 8 is working.
Yes. She is the only teacher, which is sole teacher, who is working in the school.
You inform Mr. Paske to come next week. If it's necessary, then if you pass the orders that might affect, then it'll go and appeal, it'll not being heard, come back to square one. Yes, as the counsel for number 8, who is a answering respondent, who is a person who is a necessary
Private respondent,
vital respondent. As the argument counsel for the respondent who is a vital respondent not present, it's a matter of 1 week. So you inform yourself.
Lordship.
25.
Obliged, Your Lordship.
So as per the last order, Your Lordship, the state has to come with authorities, Your Lordship.
What's the case about?
It's regarding my service has been confirmed, and then after Your Lordship, after 2023 has been regularized, Your Lordship. Service.
No, the judgment, Mr.
May it please Your Lordship. Lordship, the fact remains that Your Lordship, they have been appointed in the year 2000.
1993.
Where the judgment of this court? You've given it.
Lordship.
The judgment of this court only regarding this confirmation and authorization. Pre-confirmation and post-authorization.
No, I have not been given Your Lordship that judgment.
The judgment passed by his bench itself.
Because here, Your Lordship, what they want is done. They want regularization from the date of initial appointment, Your Lordship, which in my humble and respectful submission, Your Lordship, cannot be done, Your Lordship.
What is the...
If Lordship for the moment, if Lordship kindly have a page 10 of the writ petition.
You argued this matter last time. You argued it, right?
Ms. Bikaranlang, Your Lordship.
Page 10, Your Lordship. This is the order of appointment.
Yes.
Then, Lordship, they were confirmed in the year 2019. Lordship, kindly have page 21. And on the next page, Your Lordship, they were regularized, Your Lordship, by the Departmental Selection Committee, Your Lordship. So what they want is that, Your Lordship, their regularization ought to have been done from the date of initial appointment, Your Lordship.
Yes, what's wrong with that?
Lordship, because the file remains, Your Lordship. They were confirmed in the year 2000. They were appointed, Your Lordship. It was a regular appointment, Your Lordship.
It was a
irregular appointment, Your Lordship. That irregular appointment, Your Lordship, has been regularized in the year 2022, Your Lordship. In the year 2023. So the regularization, Your Lordship, will start from the date of from 23, Your Lordship, not from 1993, Your Lordship.
Kindly see my additional affidavit, Your Lordship.
Confirmation, Your Lordship, because confirmation, Your Lordship, just to keep permanence to the post, Your Lordship. Regularize, Your Lordship, if I may please one judgment, Your Lordship.
Your Lordship, kindly have my additional affidavit, Your Lordship, which I bring on record this notification from the Finance Department, Your Lordship.
That will not be applicable, Lordship. The additional affidavit, Lordship, kindly have page 7 of the additional affidavit filed by them, Your Lordship. So far, counting of service from the date of initial appointment for the purpose of retrial benefit, Your Lordship, I have no quarrel, Your Lordship, with that. Lordship, kindly have page S7, Your Lordship. That is the type copy of the
affidavit.
Lordship, yes. Lordship, kindly have 1. An employee who has been confirmed in the post, in a substantive holder of the post. In other words, he is a permanent employee of the government, irrespective of whether his service has been regularized or not. Therefore, the length of service should be counted from the date of initial appointment. Yes. I have no quarrel with this, Your Lordship. I have this relate to say pensionary benefits, Your Lordship. This ACP scheme, Ashok Career Progression Scheme, Your Lordship. I have no quarrel, Your Lordship. But the date of regularization, Your Lordship, will take effect, Your Lordship, from the date they were regularized, Your Lordship, not from the date of initial appointment, Your Lordship.
Whether his service has been regularized or not, Your Lordship. That my late senior counsel said.
If Lordship, if I may please. If Lordship kindly have para 10, that is 1996. 1996, 7 SEC.
Snaitang ready with the matter, correct?
Lordship, actually senior counsel. Lordship, yes, Lordship. Senior counsel is leading, Lordship.
Lordship, I'll also place another judgment, Lordship. That is, I'll keep them an advance copy, Your Lordship.
You argue the matter, we'll have it after 1 week. What is here? Now, para 10.
Para 10, Lordship. Can you have para 10, Lord? We are unable to, Lordship has got it. Yes. We are unable to endorse the direction given by the High Court regarding the regularization of the respondent medical officer with effect from 1/4/1986. The process of regularization involves regular appointment, which can be done only in accordance with the prescribed procedure. Having regard to the rules which have been made by the appellant corporation, regular appointment on the post of medical officer can be made after duly constituted selection committee has found the person suitable for appointment. Dr. So-and-so, though he had been working since 1976, was considered by the selection committee for regular appointment in the year 1981 and was not suitable for such regular appointment. Dr. So-and-so were never considered by the selection committee for regular appointment. The fact that no regular selection has been made after the appointment on ad hoc basis does not mean that they were entitled to be regularized with effect from 1/4/1986. In view of the rule prescribed the appellant, regularization of the respondent medical officers on the post of medical officer can be made only after they are considered and found suitable for such appointment by a duly constituted selection committee. As a result of the direction given by the High Court, the requirement in the rule regarding selection by the selection committee for the purpose of regular appointment on the post has been dispensed with. This is our opinion, was impermissible. Lordship, kindly see here, Your Lordship. as I have submitted, Your Lordship, they were confirmed in the year 2019, Your Lordship. In the year 2023, there was a departmental selection committee.
Did you confirm the year?
They were confirmed in the year 2019, Your Lordship.
Yes.
And the departmental selection committee sat in the year 2023. They found them eligible for regularization, Your Lordship. Then they were regularized.
21.
23, Your Lordship. 23, Your Lordship. So they found them suitable, so they were regularized, Your Lordship. Then, Lordship, if Lordship kindly have...
This case, how did it apply to the case of the petitioner? This case you cited just now.
Lordship, here, Your Lordship, here
in... to make out a case...
In this case, Your Lordship, in this...
a case that...
In this case, Your Lordship, which...
Unless they come to a regular selection process and regularize, then you cannot have post-factorization. And the date which is ad hoc. But their case is different. Their case is that they've been appointed since whatever. They were confirmed 20.
They were Lordship, as I have submitted, Your Lordship, they were
basis
confirmed.
Was the confirmation done?
Lordship.
On what basis of confirmation done?
Lordship, there was a temporary appointment in the year 2000, in the year 1993.
Authority to confirm or to regularize the services.
Lordship, so far regularization that has been done by the cabinet, Your Lordship. Then thereafter followed by
it's not regularized. Who confirmed the service? Is a competent authority or not?
Yes,
Lordship, this is confirmed by the Director of Health Services.
Then?
By the Director of Health. What I mean, what I'm submitting, Your Lordship, is that, Your Lordship, they were appointed in the year 1993, Your Lordship, confirmed in the year 2019, regularized in the year 2023, Your Lordship.
Which date should we take for counting of their services?
The date, because the date of from 1993 till 2023.
Are they retired or they're still working?
No, still working.
One of them has retired.
Say from 93 till 2023, Your Lordship, this is in the mode of irregular appointment, and that irregular appointment had been regularized in the year 2023, Your Lordship.
Irregular confirm appointment.
Lordship.
There's a new term civil jurisprudence, I think. See, Mr. Shulai, I think we're not dealing with a normal case regularization or for asking for post facto or what perspective. This case is different.
Lordship, in this case which I have cited before, Your Lordship, they were appointed in in respectful disagreement. I don't think this case will apply. But they were never regularized. Whenever any orders come in the intervening period before they were regularized. What they have prayed before
they have prayed before
the Honorable High Court, Your Lordship, is that regularized from the date of initial appointment, Your Lordship.
See, in this case, it's like this, that they can only be regularized after they've gone through the concerned selection process.
Lordship, yes, that is exactly the case here, Your Lordship.
It becomes from then. Now out here they've been confirmed. So show a case where person will be confirmed by competent authority, then regularize later on. It doesn't happen anyway. Regularization comes first, then you confirm in service. Any service person employee is appointed, regularized, and confirmed. If it never comes confirmed, regularized, then goes to selection.
If Lordship kindly have that 2006, Your Lordship, their next
how will the
judgment.
court deal with that?
If Lordship kindly have a para 16 of that judgment.
Yes.
The Lordship kindly have a para 16. The council draw our attention to the judgment of this court in so and so. This court in categorical term rejected argument that regularization and permanence and confirmation mean the same thing. Reiterating the observation made in the state of so and so. Firstly, the word regular or regularization do not connote permanence. They are terms calculated to condone any procedural irregularities and are meant to cure only such defect as are.
Sorry, I was not listening. Reiterating observation.
Let me read again from para 16, Your Lordship. Lordship, the council drew attention to the judgment of this court in BN so and so. This court in categorical term rejected argument that regularization and permanence and confirmation mean the same thing. Reiterating the observation made in so and so, Your Lordship, observe. Firstly, The word regular or regularization do not connote permanence. They are terms calculated to condone any procedural irregularities and are meant to cure only such defects as are attributable to the methodology followed in making the appointment. They cannot be construed so as to convey an idea of the nature of tenure of the appointment. It was also observed when rule frame under Article so and so are enforced, no regularization is permissible. Then Lordship 17, closure on this issue must surely be attained after the recent judgment of the consent bench of this court in so and so, Umadebi, Your Lordship. Then the consent bench in para so and so. The word regular or regularization do not connote permanence and cannot be construed as to convey an idea of nature of tenure of appointment. They are terms calculated to condone any procedural irregularities and are meant to cure only such defect as are attributable to methodology followed in making the appointment. This court emphasized that when rule framed the article so and so of the Con are enforced, no regularization is permissible in exercise of the executive power of the government under Article 162 of the Constitution in contravention of the rules. This decision and the principle recognized therein have not been dissented to by this court, and on principle we see no reason not to accept the proposition as initiated in the above decision. We have therefore to keep this decision in mind and proceed on the basis that only something that is irregular for one of compliance with one of the elements in the process of selection which does not go to the root of the process can be regularized, and that is alone can be regularized, and granting permanent of employment is totally different concept and cannot be equated with regularization. So, Your Lordship, as I have submitted, Your Lordship, the period from 1993, Your Lordship, till 2023, this come within the purview of irregular appointment, Your Lordship. So that has been validated, Your Lordship, has been regularized, Your Lordship, in 2023. So, and as such, Your Lordship, the regularization of service should come into effect from the date of from the year 2023. However, so far with retirement benefit, Your Lordship, as I have submitted, Your Lordship, I have no quarrel. Their initial appointment will have to be counted for the purpose of retirement benefit.
For 1993.
Your Lordship, yes. There are judgment on that, Your Lordship. I will not.
But not for the purpose of any financial upgradation.
Lordship.
No financial benefit.
We already have got a financial upgradation.
See, now one thing, Mr. Shrai, what were the trappings of their engagement? They given regular scale.
Lordship, if Lordship, Lordship, if then Lordship will have
a burden on you also. The only thing is that see, you have to count when they retire. You have to count from the date initial appointment towards their
for a purpose of retirement benefit, Your Lordship.
See, Mr. Paul, if
I have no quarrel with that proposition, Your Lordship.
Not affected financially because you already been given whatever dues. You have compared regular scale.
Millage.
Now, for the purpose of pension, they'll have to.
It is only for the purposes of pension only.
Count for your service from 93.
Lordship, that's what we're saying. I just draw your Lordship's attention to page 19, Millage, Annexure 3.
Yes.
So we've also been given the benefit of ACPS, Millage, from that date.
See, Mr. Shrai, then what the trappings of regular employment? Then you give them from the date of first.
Which is why, Millage, if my lords can have that additional affidavit, that one notification, Millage, that clarifies the position. This is dated 3rd of December 2014. These are in peculiar circumstances that this notification has come.
Lordship,
for the purposes of pension.
That is for the purpose of pension and all, Your Lordship.
Why they have come to? I mean, why is necessary clarification? The word the court feels is that if they have prior to 2007 will come old pension scheme.
Absolutely.
After 2007 will come new pension scheme. So for them is praying for the old pension scheme which is more beneficial.
Absolutely.
That Lordship, that is a different issue altogether, Your Lordship.
No, but that is the only issue here now. Because if you've given them a CPS, you've given them MCPS, you've given them regular scale, you've given increments, then they're not entitled to any financial benefit. Only from the date of reckoning, that's all.
Lordship, because now there are two pension scheme, Your Lordship, the old and the new, Your Lordship.
Exactly. So now
that whether they will fall, whether they will fall under the old,
they will fall under old pension scheme,
or new, Your Lordship. That matter will the department will take a call, Your Lordship.
That, my lords, would make me run around again, my lords.
No. They can't make them take a call. They will be, once they reckon, the service reckon from that date for the purposes of pay pension,
Well,
for the purpose of pension and other.
As a matter of fact, the judgment which my learned senior just referred to, my lords, comes in my assistance. If I can just read out that office memorandum, my lords, this is the 3rd December 2014. If my lords kindly have a look at it. In the additional affidavit, my lords.
That I have preferred, your lordship. That is for the purpose of ACP scheme, your lordship.
Narayana.
No, my lords. No, the Government of Meghalaya's notification, my lords.
That I have already referred before your lordship.
This would have to be read in conjunction with the judgment which has been now relied upon.
Is it filed by the state?
No, your lordship,
we have filed it by the petitioner. We filed it by the affidavit dated 11/7/2025.
Okay.
If my lords have page 7.
Yeah.
My lords have it, my lords?
Yes.
An employee who has been confirmed in a post is a substantive holder of the post. In other words, he is a permanent employee of the government, irrespective of whether his service has been regularized or not. Therefore, the length of service should be counted from the date of his initial appointment. Now, Para 2, my lords, in view of the personal department's decision to treat irregular appointments as appointments under Regulation 3F or ad hoc, and that such appointments be referred to them for their examination, regularization of service of such irregular appointees without obtaining the approval cannot be considered for the purposes of financial upgradation under ACPS scheme. Such cases should be initially be referred to PR so-and-so for approval of irregular appointments regularization if already not done. This has also been done in our case. So,
see, there's no financial burden, Mr. Shivlan.
As a matter of fact, my lords, I'll just draw your lordship's kind attention. Well, it's page 15 of my writ petition. This is in 2015, my lords.
Lord,
yes.
Well, it's this is dated the 15th of May 2015. And as this says that I am directed to convey the sanction of the Governor of Meghalaya to the permanent retention of the temporary non-gazetted posts which were originally created by this department's letter as indicated as each per statement enclosed with normalized by the Finance Department by letter number so-and-so copy enclosed which may become effective from 1/4/2012. So it is on the basis of this then my confirmation is issued.
Yes. Yes, this is a sanction for permanent.
Yes, yes, please. And my lords, the table is at page 18. Second row from the bottom, my
One
lords.
thing, Mr. Paul, how many petitioners are here?
4, my lords. Five. I'm sorry.
Separated petition.
Separated petition.
But all similarly situated.
Similarly situated, except for one has retired, my lords.
Lordship, if Lordship against that additional affidavit, we have also filed a reply. There is a reply. If Lordship kindly have a page 5 annexure 1. That is the office memorandum of dated 9 July 2025.
Reply to the additional affidavit.
Lordship, yes, because they have relied in that 2014, your Lordship.
Page 5.
Lordship, yes, annexure 1. This is the office memorandum of 9 July 2025. Whether Lordship has gotten.
Yes.
Lordship, this is subject assured career progression, modified assured career progression scheme matter.
No, this is a relaxation for Group C.
Yes,
given
Your
ACP. It has nothing to do with the case.
Because, my lords, we were already benefited. We've already got it.
No, it's not a question of them seeking financial post, what do you call it, retrospective financial benefits. They only will be calculating for the post. That memorandum is there since when? That the deregulation will be taken only for the purpose of pension and not for pay. Yes, sir, take down. Who are the... We can dispose of one common order.
Yes, yes, my lords.
Lordship, yes. Similarly,
only Michael J. Swear, my lords, that's the petitioner in WPC number 412. He has since superannuated.
Only your Lordship, if Lordship, then why the writ petitioner 5 only? Because in that annexure which they have sought to challenge your Lordship, there are number of...
No, my prayer is squad the petitioners only.
Lordship, there are 115.
No, that's squad the petitioners, if I'm not mistaken.
115, your Lordship. Because
where's the notification?
Lordship, kindly have page 22.
Of the writ petition?
Lordship, yes. And the list of the person, your Lordship, the end till 24, page 24, Lordship, that is serial number 115.
Yeah.
115. That.
This is only qua the petitioner.
I want to go to 21. Who are the petitioners here? Just pick them.
Well, it's page
21. No, confirm 29. 19.
My lords, the petitioners before my lords is serial number 5, my lords. Serial number 2. Give me the names, please. Serial number 2 is Silda.
5.
Sorry? 1, 2, 3, 5.
1. Tikimon.
Tikimon is WPC 414, my lords. Tikimon is 414. Then, my lords, I'll just give Michael is 412. Isilda is, my lords, 411.
Yeah.
Then Lurina, my lords, would be 410. And Yearly Khongwar. Show me the file of Yearly Khongwar, please.
There's not there. Manprana is not here.
Not in this letter, my lords. That's why I'm going back to her petition.
Confirmation.
My lords, Yearly Khongwar, my lords, has a separate confirmation. If my lords kindly have WPC number.
Once is separate.
Yes, my lords. Her letter is dated 30/3/2017.
It's not here in the list, one.
No, not in this list. My lords. The order is different. Date of the order is different. Because it's prior in point of time, my lords.
1, 2, 3, 4. That means only the one that is out, only that yearly.
Yearly, my lords. Yearly's confirmation is at page 19, annexure 3 of that writ petition, my lords.
His writ petition. Yearly.
Page 19, my lords. Yearly also might have retired by then.
You kindly check that.
My lords, Yearly's confirmation is dated 30/3/2017, my lords. Prior at point.
Yearly?
Yes, my lords.
That's page 19.
Page 19. Yearly is confirmed on 30/3/2017. It's prior on point of time.
That's only one apart.
Yes, my lords.
And 412 is a retired.
412 has retired, my lords. We'll just seek instructions, my lords, in case anybody else has superannuated in the meantime. We'll inform the court master in a little while, my lords.
Yes. Then we'll pass orders.
Lords.
Till 29, no?
Yes.
30.
Highly obliged.
My lord, this is a case of interstate seniority in the PHE department, my lord.
On a basis of reservation?
Yes, absolutely.
Are all the people, all the parties represented today?
Yes, sir.
Who's appearing for the private respondents 4 and 5? Yes.
On application, my lord, the Public Service Commission conducted the interview and recommended the names of 26 persons to be appointed.
That is where, Mr. Siddiqui?
White Annexure 1, the recommendation is dated 2nd August 2006, page number 24.
Annexure 1.
Page 24.
Yes.
dated 2nd August 2006.
Yes.
Thereafter, on 11 December 2006,
One overall assessment can be performed with data 6 and is found suitable for the course of conviction. Recommends also. Where's your name in the list?
in the list, my lord, number
18.
18, 21, 22, 23.
They are petitioners.
Yes, my lord.
18,
21, 22, 23.
23. Okay.
And private respondents are 16 and 20 in the recommendation select list.
16
and 20.
And 20. Yes. Patients. Okay. Yes.
Yes, especially Stone Lindo and Shalini Dora Syndrome.
Okay. Yes. Yes.
Thereafter, my lord, appointments were made. White Annexure 2, page 31. 11 December 2006.
Yes.
So here, as per this Annexure 2, my lord, petitioners were appointed by serial number 16, 17, 18 and 19.
The petitioners.
Yes, my lord.
There are 4 of 3 petitioners.
Yes, my lord. 4.
4.
Yes.
But you mark only 3 in the list. In the list you said
16, 17, 18, 19, my lord. Yes. And there it is.
Or 16,
17, 18,
17.
19.
Happy content. The
Yes.
petitioners also. Who are the petitioners?
Here the petitioners are, my lord.
2.
Ajit Charan, Sri Bilgarak. 16 is Ajit Charan, 17 is Bilgarak Marak.
No, no. In this merit list.
Oh, merit list, yes.
In the merit, who are the petitioners in the merit list? Because
Merit
we have
list
to go
is
to merit
number
list, correct?
18, 21, 22, 23.
You say that 18,
21, 22, 23.
22, 23.
Yes, my lord.
Is our Gary movement also?
Yes.
Okay. Right.
And
Okay,
then
now
they
come to
were
merit list.
appointed. It is number 16, 17, 18, 19.
Page?
Page 33, my lord. It is the appointment letter starting from page 31 and Annexure 2.
That is, where are they? 16, 17?
18, 19.
Okay.
So the name of the private respondents are not here. They were not appointed in this batch.
You appointed. Yes. 2006.
Yes, my lord. And then, as per the interested seniority list, Annexure 3, dated 5th May 21. These private respondents were appointed on 3/5/2007 and 15/5/2008. One is after 1 year of their appointment, another is after 6 months.
Page 37.
Yes. Page 36, 37, 38. I'm reading
Come
from
37 in the category. Now, where is that? Where are you?
the 30. I'm on page 38, my lord.
Yes.
This 16 number is the private respondent.
16?
Yes. Patiently Stone Lindo.
Patiently Stone Lindo, okay.
Yes, she was appointed on 3/5/2007.
Okay, yes.
And then 18 is Srimati Shalin Dora Sinrem. She was appointed on 15/5/2008.
Yes.
That is, these private respondents were appointed after the petitioner were
Yes.
appointed.
And then where is your persons in the gradation list?
21st, my lord.
Lonik Imphil Sangma?
No. Bilgarak Marak. Number 17 is Ajit Charan.
Okay. Ajit Charan movement is shown just on under one. Okay.
Yes.
Ajit
The
Charan
second
movement.
is Bilgarak Marak 19.
Yes.
Then Sri Azharji movement 20. And then Lonik Impal Sangma 21. So their appointment letter is also in the list, which only shows that the private respondents were appointed after the petitioners, much after they were appointed.
Yes.
Thereafter, my lord, as the name in the interstate senior list was shown below these private respondents, the petitioner submitted representation to the Undersecretary Public Health Engineering Department, White Annexure 4, dated 11/3/22.
Where is that?
It's Annexure 4, page 40.
Representation.
Yes.
Yeah.
In this representation, my lord, the challenge that their name should have been above the private respondents as they were appointed earlier in time. Then, while submitting the representation, they also referred to judgment of this honorable court, WPC number 301218, and that party's name is Vinjay Rosila G. Momin, and sorry, only one judgment was referred there.
What does judgment say? Where the operative parts?
Operative part of the judgment, page 5. My lord, it is page 47. It is enclosed there.
Yes.
Page 47, paragraph 15.
Yeah.
There is no doubt that in view of the reservation policy, open or unreserved category candidate who fared much better than the reserved category candidate could not be appointed in the year 2010. Some of such candidates may have got the appointment in 2012, but it is completely outlandish to suggest that since the candidates recruited in 2012 obtained more marks than candidates recruited in 2010 or ranked higher in the merit list of September 7, 2010, such subsequently inducted employees would stand on the same footing as the earliest recruited employees 2010, or there would be any need for determining the interstate seniority. The persons appointed in 2010 and the persons appointed in 2012 is completely defies logic and reason. This is the finding one. So they have referred this judgment. In reply to, but as no action was taken on the judgment on this representation, my lord, in the meantime, another interstate list was published. There also the position remained the same. The petitions were below the page 50, my lord.
Starts from here.
Here, my lord, the petitioner's name appears at number 10, 11 in the cadre of subdivision. Page 51 in the cadre of subdivision officer. Page 51, annexure 6.
SDO.
Yes, my lord.
Okay.
It says that in the cadre of subdivision officer, assistant engineer, civil PHE.
Okay.
Here the petitioner's name appears 10, 11, 12, 13.
10, 11?
10, 12, 13. 14.
Sorry, madam. 10, 12, 13 and 14. This is below the names of the private respondents.
14.
Yes.
9 and 12.
And the...
So 9 and 12 are the private respondents.
Okay, yes, got it. So, which dates in seniority?
Interstate seniority is dated to 11th April 2023.
Okay.
So being agreed, again they submitted another representation, White Annexure 7, page 53, dated 25th May 23.
Dated?
So thereafter, my lord, a representation was submitted, White page 53, Annexure 7, dated 25th May 2023. So in this representation also, the first judgment which they had submitted were also enclosed, and another judgment of Janera was also submitted here. So Janera judgment, my lord, says at page 61, paragraph 15.
I have 15.
Yes, madam.
Okay.
Thus, it is evident that the private respondents were not given any appointment against the initial 9 vacancies that arose in the year 2007, but they figured in the list of 12 candidates recommended by the State Public Service Commission dated September 13, 2007, and they were appointed against casual vacancies which arose after the writ petition, and 5 others had already been appointed on June 2008. My lord. So here what it says, my lord, the vacancy advertisement was made for 9 seats only, 9 vacancies, but recommendation was more than that as per the rules. So those 9 seats were filled, and select list was exhausted. After that, they were appointed. So this Honorable Court held that those who were appointed after the vacancy was over and the list was exhausted, they cannot be made above the petitioners, although their name appeared in the select list above them. In the select list, merit list, they were above the private respondent, but still the Honorable Court held that no, it cannot be done like that. Because the vacancy was for only 9, once it was filled up, then those remaining thereafter will not be in a position to get a better appointment. That is yes. All their select list will not be valid anymore. So, my lord, in our case also, this representation was rejected on 2 grounds, my lord. Ground number 1 was that judgment which was quoted by the petitioners is in respect of the Meghalaya civil services, and these are the PHE. So therefore,
where is that rejection?
This rejection is at page 66, annexure 10.
Page
66, annexure 10. So their representation was referred to Law Department for their views, and that view is quoted here in the rejection letter, my lord. For the above mentioned reason, we advise your department to dispose of the matter in accordance with the governing service rule. Further, it may be added that the judgments of the High Court of Meghalaya cited by the aggrieved officer is not relevant to the facts and circumstances involved in this instance case, inasmuch as the rules governing the 2 services, that is CS and MPS, and the officers of the PHE are completely distinct to each other. This is the ground number 1, my lord. Number 2, further, you are also requested to refer to the instructions contained in para 8B7 of Personnel Department dated 14 June 2023 governing the relationship between the reservation roster and seniority. So 2 parts are that MCS rules and the PHE rules are quite distinct from each other. Second, in view of that is at lecture 11, my lord, that so page 68, my lord, paragraph 7. It says that, my lord, the reservation roster is only to ensure the implementation of the reservation policy. The reservation roster does not determine seniority. Seniority will continue to be based as per the existing rules.
Yes.
So existing rule says that the select list will prevail. And over and above that, even if a person is not appointed because of roster, then even if he will be appointed later, then also that seniority will continue. So, my lord, in this section, I would like
where
to...
the rule that says as per select list?
Select list is, I have included the rules, my lord. PHE rules, page 100, my lord. That is clause 20, seniority. And
page 100?
Page 100, clause 20 and subclause 4, 20, subclause 4 in 101, page 101. my lord, it says that the inter-se seniority of the members of the service appointed to different cadres after the commencement of these rules shall be in order in which their names appear in the merit list, prepared under sub-rule 4 of Rule 13, Rule 11, or in the select list approved under sub-rule 5 or Rule 10 or sub-rule 4. So it means that in the selection list will prevail over the date of appointment, according to these rules, my lord. And therefore, the department held that although judgment is there, but it is for the MCS, it will not be applicable to PH. But this is not the case, my lord, because this selection list will prevail. It is here in clause 20 of the service rules, my lord. But let us see MCS what it is. It is. Please come to page 121, my lord. There. 120.
Page
124. 124, my lord. Rule 16. Rule 16, clause 4.
Yes.
It says same thing. The seniority of the members of the service recruited after the commencement of these rules shall be in the order in which their names appear in the list prepared sub Rule 4 or Rule 5 or 6 approved under Rule 8. Provided that the members of the service recruited in the year under the clause B of sub Rule 1 or Rule 5 shall be senior to the members recruited in the same year under clause A. So that is not there, but in any way it also means the same thing. The seniority list will prevail irrespective of the date of appointment, my lord.
Sub Rule 4, Rule 6, let's see.
Yes.
Rule 6.
Sub Rule 16. 16 Sub Rule 4. The seniority of the members of the service
No. It'll be, let's look at Rule 6 of this rule, or MCS rule.
Rule 6.
Rule 4, 6.4. The commission payable candidates.
16.4, no, 6 is not there, one.
6 is there.
He said Rule 6.
Recruitment
Rule
council
6.
examination.
Okay, yes.
Come to page 1119.
Yes, sir.
Yes.
The commission shall prepare a list of all candidates who have qualified in the examination in order of merit, which shall be determined in accordance with the aggregate marks obtained by each candidate. If two or more candidates obtain equal marks, the commission shall arrange them in order of the relative merit, which shall be determined in accordance with the general suitability of the candidate for appointment to the service. The list shall be forwarded to the governor and published in the Gazette of Meghalaya. The inclusion of candidate's name in the list shall confer no right to appointment.
No, but then the rule of PHE says that it clearly says merit. Here does not say merit.
No, but it says in 20, Rule 20, Sub Rule 4. 16, sorry. In 16, the 20 there in MCS is 16 here. 16.
It didn't appear in the rules 4. Rule 4, see, the seniority of members shall be after government rules shall be in the order in which the names appear in the list prepared. Sub Rule 4, Rule 6. Sub Rule 6 says the commission prepares organs who have qualified examination. Not of merit shall be determined upon the judgment. So. Yes.
So it is same thing that the select list will prevail on the date of appointment. So on these two grounds, my lord, and another ground is that about that the rule which I have just read the notification that select list will prevail even if the person is not appointed due to roster problem. Then even if you are appointed later on, he will remain the senior because of the seniority list, my lord. This is the year. But my lord, I submit that the select list means the valid select list, not which is invalidated because of lapse of time or for any other purpose. So according to...
No, I'm not catching. You're saying, what is the submission of Siddiqui just now?
I am submitting that the select list will prevail only if it remains valid at the time of appointment, my lord. If it is become invalid due to lapse of time or for any other reason, then that will not prevail.
So your contention is that they are appointed after the 1 year validity of select list?
Yes.
Suppose the validity has been extended by orders?
No, that will not do here because the validity of this, it is exhausted. Total requirement was 9 only, for which, 19, for which the advertisement was made. And 19 were appointed along with me as per the required order, my lord. And thereafter, the list is no more. It is exhausted. Once it is exhausted, under the Meghalaya Public Service Commission rules, It is page 3. It's not numbered here. Page 3, my lord.
Yes.
It says general, part 1, general.
Yes.
The appointing authority will inform the Public Service Commission of the number of vacancies reserved for scheduled caste or scheduled tribes and backward classes.
Yes.
In the case of service in which permanent vacancies occur through the year, the number of vacancies to be reported to the Commission should be the number likely to occur during the required recruiting year, and no vacancy which occur after the end of that year shall be filled without a further reference to the Commission. Which to say the Commission has recommended keeping in view that 19 vacancies, and after it is exhausted, if there is any further vacancy, the department will have to consult the Commission again, and again the same process will start in that, and that select list will prevail, not with the present 19, my lord. In this connection, my lord, I am referring to one judgment of Supreme Court of 2009. Man. Where it is? 32. In this, my lord, paragraph 32. Oh, sorry, 33, my lord. At the outset, it should be noticed that the select list prepared by APSC could be used to fill the notified vacancies and no future vacancies. If the requisition and advertisement was only for 27 posts, the state cannot appoint more than the number of posts advertised. Even though APSC had prepared a select list of 64 candidates,
Are you challenging the appointment also?
No.
No, I am not challenging. No, I am not challenging. Only
that argument is beyond the pleading, your lordship.
no, I am
It's
not
beyond the pleading.
No, I am not challenging. Only saying that the.
So how can you draw a sustenance from this fact that your submission just now was that whatever it be, the select list was prepared. There were 19 vacancies.
Yes.
There were a certain number of
19 were appointed.
And the 19 vacancies have been filled up.
Yes, madam.
And so that puts a closure to the entire selection process as it stood on that day, correct?
Yes, madam.
And if future vacancies arise or there's
Yes.
then that be a fresh selection process.
Yes, madam.
And that these private respondents, in spite of the fact 19 they were accommodated from the same select list to the future vacancies that were there.
Yes.
In 2000 and whatever.
Whatever.
So then, but that's not your case here. Your case is your seniority.
Yes, my lord.
You're not questioning the appointment.
No, I will not explain. I will not. I am not on that, my lord. It is up to them. They are the chance beneficiaries. They got the chance. But even if they are appointed, they cannot be above the petitioners, my lord.
So your simple case is that whatever it be, in this case, seniority should be on the intake itself.
Yes.
The similar situation, whoever suppose 10 candidates were taken, appointed, the intake in that particular year
Yes.
was 10.
Yes.
Then in this seniority will be among them only.
Yes.
Yes. And then if intake again from maybe from the same list is after 2 years,
Yes.
they'll fall in a different
Yes, different selection
category
process will be
altogether.
there. Yes, that is this ruling also says, and the Meghalaya Public Service Commission Act also says the same thing.
Yes.
Yes, so Mr. Malvetter, I submit that the select list is wrong here. Interested seniority list. My names of the petition should be above the primary importance.
So it'll come down to interpretation of the rules.
Yes,
whether
Madam
the rules allows the. Yes, Mr. Shulai.
I may please your lordship. If lordship kindly have page 24 of the writ petition, your lordship.
Page 34.
24, your lordship, yes. That is the select list published by the Meghalaya Public Service Commission.
Yes.
If I take your lordship, kindly have a page 26.
Yes.
Lordship, kindly see serial number 16.
Yes.
16 is the private respondent. 18 is the petitioner. Lordship, 20 also is a private respondent. 21, 22, 23, these are writ petitioner, your lordship. Then I take your lordship to the accreditation list, your lordship. That is accreditation list of 2024. Lordship, kindly have page 72 annexure 12.
But that's not been placed by the Mr. Siddiqui.
Lordship, kindly have page 72, your lordship. 72.
Yeah.
that Annexure 12. Lordship kindly have page 74. Lordship kindly have this second column in the cadre of subdivisional of assistant engineer civil PhD. Lordship has got it. Lordship kindly have serial number 7.
Yes.
Serial number 7, private respondent. 8 is the writ petitioner, Your Lordship. 9 is a private respondent. 10, 11, 12, Lordship. These are writ petitioner, Your Lordship.
8.
Lordship, 7 is the private
11,
respondent.
12.
8,
yes, okay.
8 is a writ petitioner.
Yes.
9 writ petitioner. 10
Yes,
writ
no, yes,
petitioner.
got it, that up to 12.
Up to 12, Your Lordship. So, Lordship, this credition list is perfectly in order, Your Lordship, in terms of the select list published by the Public Service Commission. Lordship, kindly, this, Lordship, because this it's a Lordship, the seniority list will have to be determined on the basis of the select list issued, published by the Public Service Commission. If I take Your Lordship to the rules, Lordship kindly have a page 88. That is the PHE rules 1996. Your Lordship. Lordship, I'm taking Lordship.
88 of the repetition.
Lordship, yes.
Is eligible. We can't read this.
Lordship, it's a type copy, Your Lordship. There is a Lordship. I am referring from the type copy, Your Lordship.
Yes. Oh, 88,
88, Your Lordship. Lordship,
the pages. Yeah.
Lordship, I am taking Your Lordship to page 100. Seniority. Seniority.
Yes.
Then Lordship kindly have turn to the next page, Your Lordship, at page 1014, Your Lordship. May I read it, Your Lordship? The entire seniority of the members of the service appointed to the different cadre after the amendment of this rule shall be in order in which their name appear in the merit list prepared under sub rule 3 of the in the select list approved under sub. So there was a select list, Your Lordship, published by this by the Public Service Commission, Your Lordship.
Yes.
His name, Your Lordship, the principal petitioner, Your Lordship, at serial 18, the private respondent, Your Lordship, at serial number 16. Then, Your Lordship, the second private respondent at 20, the other writ petitioner at 21, 22, 23, Your Lordship. Is perfectly, Lordship, in tune with the service rule, Your Lordship.
What about MCS rules?
Lordship, that is that is pari materia, Lordship, with the rule. In my humble respect,
been held that this is wrong by the division bench of the
Lordship.
court.
In fact, Lordship, I would rely on the judgment rendered by this honorable court. If Lordship kindly have this judgment also has been tested before the division bench, Lordship. If Lordship kindly have para 11 or para 10, Your Lordship. Para 10, Your Lordship, internal page 7. May I read it, Your Lordship?
Yes.
As the entire case rests upon the rules and their application, it would be expedient, therefore, to discuss and interpret the same in the context of the claim made by the petitioner. Rule 9.1 of the rules provide for appointment of lower division assistant by way of a direct recruitment. Lordship, here also, they are all direct recruits, Your Lordship. The entire seniority among the lower division assistants is governed by Rule 29 and in instant case, more specifically, 29.1b, which provide that the seniority of the lower division mentioned in clause 3.1b of the rule shall be in order in which their name appear in the result of the committee conducted by the commission. Exactly the case here, Your Lordship. Then Lordship has quoted the rule, Your Lordship, that is a rule 9.1, then B, Your Lordship. Kindly have CB. Persons are recruited as lower division assistant and typists in the offices of the head of the department mentioned in column so and so on the result of the committee conducted by the commission.
Yes.
Then Lordship kindly see D, Your Lordship. the intercessor or the assistant appointed shall be in the order in which the name appear in the list respectively. Lordship, then 29, Your Lordship. 29, Your Lordship. Rule 29, Lordship. Kindly see at page 8, Your Lordship. The seniority of the lower division as mentioned in B of sub-rule 1 of Rule 3 shall be in order in which the name appear in the result of the competitive examination conducted by the Commission. That is exactly the case here, Your Lordship. That is, Lordship, my humble and respectful submission, Lordship. This rule, Your Lordship, in all these regulations are pari material, Lordship. They are almost same, Your Lordship. And Lordship, this judgment rendered by this honorable court also has been tested, Your Lordship, in writ appeal. If Lordship kindly have para 4 and 7. Para 4, Your Lordship. Lordship has gotten. In this case, there is a clear rules in term of Rule 29(1)(b) that provide that inter-se seniority of lower division assistant would be in order in which their name appears in the result of the competitive examination conducted by the Public Service Commission. Then Lordship kindly have para 7, Your Lordship. It is plain to see from the inter-se seniority list of November 17, 2020 that while the appellant ranks 68 in the merit list, the 3 private respondents rank 58, 55, 53 in the same merit list. And it's also evident that the merit list pertain to the same recruitment process, exactly the case here, Your Lordship, irrespective of when any individual actually join the service. The seniority and credential list would have been on the basis of mark obtained in the recruitment process and position in the merit list. So the answer is very clear, Your Lordship. This inter-seniority list, Your Lordship, will have to be determined on the basis of the select list published by the Commission.
No, just come back. I would just come back to the rules. That's the only thing.
Lordship, kindly have at page 100, page 100, Your Lordship. That is seniority, page 100. Then 101, Your Lordship, subclause 4 or subsection 4, Your Lordship, at page 101, Your Lordship.
Compared with the MCS rules which have been interfered with by this court regarding seniority in the other cases?
And that, Lordship, in my humble and respectful submission, Your Lordship, that judgment in the MCS case would stand eclipsed by the division bench judgment, Your Lordship, rendered in
both of them division bench judgments.
Lordship.
See, the only thing we just have to discern the difference between the MCS rules and the PHA rules.
MCS rule is, Lordship, I'm
only for the
Lordship kindly have
be clear.
Lordship kindly have page 115. That is the MCS rule. Then Lordship kindly Lordship kindly have a page 124.
119 first.
Lordship, yes.
164.
Lordship, yes. 64. The Commission shall prepare a list of all candidates who have qualified in the examination in order of merits, which shall be determined in accordance with the aggregate marks obtained by each candidate, and if 2 or more candidates obtain equal mark, the Commission shall arrange them in order of relative merits, which shall be determined in accordance with the general suitability of the candidate for appointment to the service. The list shall be forwarded to the Governor and published in the Gazette of Meghalaya. Then Lordship kindly have
1 to 5.
Lordship, yes, 1. 16.4, Your Lordship. Lordship kindly have a 1 to 5, Lordship. Yes, thank you, Your Lordship. The seniority of the members of the service recruited after the commencement of this rule shall be in order in which their name appear in the list prepared under sub-rule 4 of Rule 6 or approved under Rule 8.
Then what's the difference between?
Then Lordship kind
sub-rule 4, Rule 6 has a commission. Then all candidates have qualified in order of merit.
Lordship.
Then if you say there's not the members,
if Lordship kindly have page 96. of the writ
Only this
petition.
part you have to clear.
Lordship kindly have page 96 of the writ petition. That is the recruitment rules of the service rule of the PHE, Your Lordship. If Lordship kindly have page 96, Your Lordship.
Yes.
Lordship kindly have sub rule 4. On the basis of the result of the examination, the Commission shall prepare a list of all successful candidates in order of merits. Your Lordship, the wording is same, Your Lordship, in all the rules, Your Lordship, which shall be determined in accordance with the aggregate marks obtained by each candidate, and if 2 or more candidates obtain equal marks, the Commission shall arrange them in order of relative merit, which shall be determined in accordance with the...
But I think that what's the difference? Show me the discernible difference between the MCS rules and the PHE rules that you want to give different standards of interpretation.
Lordship, in fact, in my humble and respectful submission, there is no difference.
Then how can the two judgments conflicting?
Lordship, Crispilla is of 2023, Your Lordship, and the judgment, the division bench judgment also 23, Your Lordship, and the judgment of MCS case come. Lordship, Lordship, in the year 2022, Your Lordship.
Then for a division bench.
Lordship.
How do you
My Lord,
propose to get out of this
my
quagmire?
My learned friend has made submissions, but nowhere he could say that select list should be valid. And here, according to their
validity, you are not challenged, so it's not up for consideration. The thing is that now whether if the two parameter here, we come into the problem with this court is that division bench on one hand has said that no, if it's just 1 year, it has to be the same year, whatever, same intake at the intake. And
but there it was not discussed, my lord, whether it is that 19 vacancies or any number of vacancy.
No, vacancies will have no. In your case, you're not making a case about vacancies.
Yes, it is
the
there.
Simple case is that I was appointed in years of 2000.
In 2007, Your Lordship.
And Mr. Shulai appointed after 2 years, and because
it's only here 1 month. It's a matter of months only, Your Lordship. It's not years, only 1 month or 2 months.
The appointments.
Yes, Your Lordship. If Lordship kindly have
not be consideration, even if it's 1 day also, it'll be.
Lordship kindly have a page 7 of the writ petition.
Even when suppose for judges seniority also suppose you take oath at 10:30, the other one same day takes at 11 o'clock, who will become a senior? So, yes, Mr. Sen, you have any?
No, one more point, I want to add. In the affidavit in opposition, my lord, filed by the government, respond number 1, 2, 3.
We have reiterated the same thing.
Yes. So, may I read from paragraph 7 and 8?
So, your submission, Mr. Shulai, is that they're parameter here?
Lordship, yes.
But different standards have been given.
No, Your Lordship, yes. Lordship, yes, there are 2 judgments.
So, for which is convenient for Mrs. Siddiqui, she's adopted it, working for you adopted it.
Lordship.
And my lord, I am focusing more on the validity of list after 19th or 9 number.
Go there.
But it is their case, in their pleading it is said.
It doesn't matter, we can't go there. Once you have not made a case of wrongful appointment.
Their simple case is, Your Lordship, I have been appointed earlier than the other, Your Lordship, I should be placed above them, Your Lord.
No,
that is their simple case, Your Lordship.
My second point is also there, my lord, that no, once the validity of the list is no more or it is exhausted, then these parameters cannot be adopted.
Let's say 5 minutes, then that I will not close the matter today. Let me just think about it. Yes, Mr. Sen. What do you have to say?
As I'm adopting the submissions made by my learned senior for the state, of course there does appear to be a divergence, but Lordships will see it's the same bench. And my lords will also notice there is a distinction.
One is the bench of
Justice Banerjee, my lord.
Banerjee and
he headed
one is Banerjee and
all 3 cases. All 3 cases.
All 3 cases.
There is Winji Marak, there is Zanira, and then there is Krishpila. All 3. Now, there are two
And
judgments.
you appeared there also.
Yes.
Then why didn't you place early judgment, Mr. Siddiqui, when this matter was taken up? This Kripshila and the division bench.
The Kripshila I was not there about.
Of course, your name figures here very prominently.
Oh, sorry.
How?
Yes, you are there.
You are the lead counsel.
Yes.
Yes.
And
Vinjay and Janerat, I remember that I had it.
No, fine. That's why you're there in all the cases you're there.
Yes.
Then what are we to do? The larger bench.
I believe they're all friends. It's the same network of friends. Because even here, my learned senior is appearing, they've borrowed from the outcome of Vinjay and Zanera, and then they filed this case in 2024. I'll just take your lordship through the timeline. They're all fence sitters, actually, in my humble submission. They were waiting for the outcome of Vinjay. Friends. And they're fence sitters. Well,
no, another consideration is that one thing. If gradation list has been in place since when was it first brought out?
These appointments are all made. That's my point, Willots. From 2006 onwards, and the last appointment was made in 2007.
Even might be regular, Mr. Siddiqui, looking at another consideration, you can't settle position.
Yes, in 24, when my petition, my representation was rejected, my lord, this point was not taken by the government that they are coming to.
Not required. I'll take your lordships to this point. I'll just take your lordships. Yes, my lord. My lord, I'll be very brief, my lord. Just notice a couple of things. The last appointment was made of the respondent number 5 on 15/5/2008. The first appointment is made in 13/12/2006. As far as the contesting parties are concerned, this is the width of the nature of appointments of all these parties. If lordships have page 7 of the writ petition, page 7 of the writ petition.
Yes.
Kindly see para 5.
Yes.
Now, the Roman serial number 4 is petitioner number 4.
No, I understand because one it came in the middle, that Mr. Number 4.
Yes, so these are
senior
the people.
to 3, but junior to 1.
Yes. So the senior most, according to them, would be in terms of appointment, date of appointment is petition number 4. Then it is petition number 2, petition number 3, petition number 1, and then finally number 4 and 5, the respondent number 4 and 5. Now, what is under challenge, my lord, in this writ petition? Kindly see at page 18. This is very interesting. The gradation list of 24. Only that is under challenge.
23.
24.
Oh, then.
Only the gradation list of 2024 is under challenge. Now, after their appointments as far as 2008, the first set of gradation list, placing all these people in whatever standing they are, that appeared in 2009. And lordships are aware, before when a draft gradation list is issued, they're given 60 days time to raise an objection. They did not raise any objection whatsoever. I'll take your lordships to the first notice, one of the notices at page 36. This is from 2021.
No, you said the first gradation list was.
That is 2009. I don't have that. I'll take your lordships to my pleadings as well. Kindly see the draft of the notice that is issued as page 36, my lord. This is 5th May 2021.
Yes.
It is a seniority list of Gazette officers of PhD department as on April 2021 is hereby circulated for information of all concerned. The officers mentioned in the list may submit their representation, if any, regarding omission incorrect entries in respect of their individual case, duly supported by documentary evidence for examination necessary action within a period of 60 days from the date. So from 2009 up until 2024, no real objections were filed, especially within that 60-day period. The next notice which is issued is at page 72.
Okay, we understand.
There are sporadic representations, but these are all after the outcome of Vinjay Marak.
What will be the correct position of law with regard to this, if it's paramount only thing?
That is one part, my lord. Now, I'll just draw a distinction with regard to Vinjay Marak's case. Please see page 42. This is Vinjay Marak's case. Now, the bench was very, very careful in passing this order, and the factual dissimilarity has been specifically noted by the court. Please see page 48 of the judgment.
Yeah.
Page 48, para 19, my lord.
Yeah.
The writ petition was instituted upon the representation given by the petitioners in the year 2012 and again in 2014 being disregarded. Since the petitioners had objected to the seniority list in 2012 itself and renewed the dissent in 2014 and had approached the court in its extraordinary jurisdiction shortly after the subsequent representation was rejected, there does not appear to be any delay on the part of the petitioners in approaching this court at any rate. In the context of so-and-so case, the court has taken notice of the fact that they have come immediately. And in fact, in the facts it is indicated that the seniority list, insofar as this case is concerned, was prepared in 2012. So in 2012 and 14, they immediately raised their protest. So court notices this fact and therefore interferes in this matter. Now, on this particular issue, my lord, that in service jurisprudence, if a party seeks to raise any issue with regard to a challenge on seniority or inter se seniority or promotion, it has to be done within a reasonable time. My lords, we'll turn to para 18. This is at page 1313. Sorry, this is not a true copy, my lord. I have flag marked that page. Para 1818. May I read, my lord?
Yes.
The question of entertaining the petition disputing the long-standing seniority filed at a belated stage is no more res integra. A constitution bench of this court and so and so considered the effect of delay in challenging the promotion and seniority list and held that any claim for seniority at a belated stage should be rejected inasmuch as it seeks to disturb the vested rights. Yes, my lord. And in fact, PC page 20, para 21, my lord.
Yes.
This is a judgment of a larger bench, if I am not wrong, and they've extracted para 7 from the judgment. A government servant who is appointed to any post ordinarily should at least, after a period of 3 to 4 years of his appointment, be allowed to attend to disputes attached to his post peacefully without any sense of insecurity. And further, there are other. There's an extract of various judgments, my lord, and they say it has to be done within a reasonable period. The conclusion is at para 30. Lords may look through para 18 up till 30. They have extracted several judgments.
Digested all the.
My lords. Para 30 is their conclusion, my lords. And my lords, I have raised this objection in my affidavit in opposition. In their rejoinder, they do not address the issue of delay at all.
I have a problem of shortage of personal secretaries. Of that only thing generate judgment. You have a problem. Yes, it's my turn.
Item 25 to 29 have instructed that between item 25 the petitioner is still in service. From 26 to 29 they already retired.
All retired? I don't you note down? Item 26, 29 all retired. Who's the one service? Revenue number? Huh? Okay.
WC 410-2024.
410.
Civil service.
Anything else, should I?
That's all, your lordship.
Yes.
Content 5 in 36.